Thank you for tuning in to the Heart of Law podcast. My name is Mirena Umizaj, and I'm your host. I always look forward to recording this podcast as it creates a space for me to learn more about my guests, but also shed light to topics that are of interest in the legal industry today. My guest is a very sought out ethics attorney, and her name is Lynda Shely, based in Scottsdale, Arizona. A very intelligent, sophisticated, and experienced attorney that has helped shape the legal space. Lynda has provided ethics advice to over 2,000 firms in the United States on a variety of legal ethics and risk management topics. She currently serves on the Arizona Supreme Court's Alternative Business Structure, ABS Committee. She is the 2020-2023 chair of the ABA Standing Committee on Ethics and Professional Responsibility, an Arizona delegate in the ABA House of Delegates, a member of the State Bar of Arizona Ethics Advisory Group, and the president of the National ABS Law Firm Association. Lynda, welcome to the Heart of Law. How are you today?
I'm great. Thank you for having me today.
Thank you for saying yes, because I've been thinking about this podcast for quite some time, so I'm glad we made the time. I invited you because I think you are a fascinating lady and have been obviously at the forefront of significant change. And this change allows lawyers and non-lawyers to share fees in Arizona. This obviously isn't the first time in the history of the judicial system in America, because I believe Washington, D.C. Was the first state that made this, and maybe you can shed some light and educate me on it. But before we dive into the fascinating topic, I really wanted to know why you chose to be an ethics attorney and perhaps share a little bit more of your background with us.
Okay. I'm chuckling because, the honest, truthful, ethical answer is I became an ethics lawyer because we had 3 children under the age of 3. Literally after we had moved to Arizona, I had practiced in Washington, D.C. at a very large AmLaw 100 firm doing intellectual property work. Loved it. But we moved to Arizona, and once I became outnumbered by small people at home, I literally went to a friend of mine at the State Bar of Arizona, and I said, oh my gosh, please give me something to do a couple days a week. And we created the ethics hotline, which virtually every state bar association in the U.S. now has, where lawyers can call and ask for advice if they have a question about what they can and can't do under the rules. So that's how I became an ethics lawyer, and I worked at the bar for 10 years. And for the last 20 years, I've been in private practice, representing law firms.
What do you exactly focus on representing law firms?
It's a niche of providing advice to lawyers before they do something. I don't handle any litigation. I advise firms on how to write their fee agreements, how to comply with the very detailed rules we have on lawyer advertising in various states. What is a conflict of interest, how to maintain confidentiality, how to train their employees on how to comply with all the ethical obligations that lawyers have to follow. So any number of things. Anytime I pick up the phone, it could be a firm in any different practice area, and I believe I represent firms in every practice area. So I have to understand the ethics rules, but not necessarily be very detailed knowledge of a specific practice area like mass torts or estate planning or tax.
Right. So you serve as a guiding system, right, to attorneys who are either creating, new opportunities or dissolving current opportunities or somewhere in between. There is a broad spectrum, I assume. So my understanding is that you are, and again, we've talked before, but we haven't necessarily had this specific conversation. So this is also to enlighten me. My understanding is that you were one of the key people that took the initiative for the 2021 rule changes, now permitting Arizona lawyers to form law firms with non-lawyers as owners or investors or partners. What does the elimination of Rule 5.4 mean? Can you share with our audience why you decided to spearhead this effort?
Well, and I was merely one of a couple of ethics advisors to a task force that our Arizona Supreme Court created. And the Arizona Supreme Court created a task force on the future of the profession to look at a couple of issues, not just access to justice, which we all know there is a huge gap in getting legal services to people who need it, not just pro bono or free services, but simply informing folks that they might have a legal issue and how to get legal services. But this task force also looked at kind of holistically the rules that regulate the profession. And the Arizona Supreme Court's task force, with some input from some of us who are ethics lawyers, looked at the rules, and one of the rules that they were reviewing was Ethics Rule 5.4, which is the rule, as you said, that prohibits lawyers from both sharing legal fees with non-lawyers and having a partner who's a non-lawyer. And you mentioned the District of Columbia rule. DC actually changed their rule in 1991, but it's a very narrow change. They still have Ethics Rule 5.4, so DC lawyers still can't share legal fees with non-lawyers outside of the firm. But what the DC rule permits is, like, I'm a DC lawyer, Mirena, you're not a lawyer. We could partner. Just you as an individual, you could partner in my law firm in DC if you're assisting in some way in the delivery of legal services, like providing financial planning advice to the clients or a CPA, things like that. The DC rule does not, however, permit what is referred to as passive investment, simply having somebody say, I want to own 50% of a law firm and then get a return on that. The DC rule does not permit that. But in Arizona, our task force looked at the rule and really kind of looked at what else was going on in the whole world, not just the US. And they looked at the fact that the UK has had these alternative business structure law firms, and an ABS is simply a law firm that has some non-lawyer owners. The UK has had ABS law firms for years, and so has Australia. They've had them, and they've been able to demonstrate that, look, this provides capitalization to firms, which frequently lawyers are not good at finding capitalization for their firms. It also provides incentives to key paraprofessionals, because I know we all have issues with trying to maintain our staff and keep quality people. And if you give them some equity, some ownership interest in the firm, you're not telling them that they can practice law. And that's, by the way, I'm going to say it probably a couple of times during the podcast because it's kind of a confusing issue. The ABS law firms in Arizona do not permit non-lawyers to practice law. That's not what it did. All it did was permit lawyers to partner with non-lawyers. And it could be investment into the firm, or it can be, as I mentioned, a key person, or partnering with another professional like the DC rule, an accountant, financial planner, social worker, whoever. So that's what the task force was looking at this as. Is this rule needed to protect clients, or is it out of date? Because realistically, if you look at a law firm, they have employees who are not lawyers. How are they paying their salaries? Because they charge legal fees, right? And then they have revenue, and that's how they pay their staff. So our court was willing to try this program to both eliminate 5.4 completely, but then to put a very structured and detailed regulation and registration process in place if a non-lawyer wants to have an ownership interest in a firm.
Thank you for that. That makes a lot of sense. And I think I was aware that lawyers, non-lawyers could share fees within the firm in DC. And that clarification does help. So what are some of the common misconceptions about, I'm sure you hear this and you've heard this, about what could go wrong with this type of arrangement?
Probably the number one misperception about Arizona's program is that it permits non-lawyers to practice law. And that's not true. It's just not true. The other, and I would say this is a legitimate concern, lawyers express concern, if we're going to have non-lawyer partners, all they're going to be interested in is the bottom line. And they're going to tell me I shouldn't take depositions because they're too expensive. And they're going to try to, I get that. And that's a very legitimate concern. People would point to perhaps the medical industry having corporate takeovers and having perhaps healthcare not be based just on the doctor's recommendations, but on the bottom line of how much things cost.
Yeah.
Arizona's ABS program, though, is designed to hopefully prevent non-lawyers from controlling the legal decisions that lawyers make, including even, how much is a deposition going to cost? I guess we can't afford that. The ABS regulations are very detailed in saying, non-lawyers, you can own 100% of an Arizona law firm that we approve. It has to go through the ABS committee, and you have to get all the non-lawyers, including all the companies, approved by the ABS committee. You can own 100% of the firm, but you cannot direct the legal representation of clients or even which clients the firm will represent.
And I guess that's where the rubber meets the road, right? So obviously, let's take mass torts, for example. Mass torts is an area where a lot of capital has entered the space, and you can make an argument that Wall Street sees the legal system now as a really major opportunity to diversify their risk. And because, mass tort isn't necessarily directly linked to the market, that there is a lot of upside. And so hundreds of millions, billions of dollars have been deployed into mass torts. And it is many times a messy business. Is it going to be easy for lawyers and non-lawyers in those types of arrangements where mass torts is the inventory, the collateral, to do business in a clean, professional, complying with the ethics kind of way? Or is Wall Street ultimately going to dictate, what kind of inventory is acquired, how those cases are worked up? And yes, you can have a lawyer there and talk to the clients and, quote the law, whatnot, or go and have a trial. But ultimately, the decision making in terms of the economics of the firm is made by the people who are making the investment. So what's your take on that?
Well, let me ask you a question back first. Isn't that happening in law firms across the country? Isn't Wall Street already investing in mass torts by loaning money to law firms? They're already doing that, right? And
as a debt structure. Yeah.
Correct. And we know that in that debt structure, law firms are very reticent to disclose who's loaning them the money or that they even have some debt that they owe to Wall Street. And I would suggest that this is already happening. And I know lawyers who are not involved in mass tort might be shocked at the amount of money that's in the mass tort arena through litigation funding.
Yeah.
The ABS program actually is more transparent than the existing litigation funding in other states. Because where you have a law firm in, Florida or New York or someplace else that borrows money to be able to pay for all of the advertising that they have to do and all the expert witnesses, in the ABS program, you know exactly who's involved with that lawyer because it has to be disclosed in the application.
Right.
So I would say that the ABS law firm process is much more transparent than regular litigation funding. And you have the lawyers in the ABS law firm having to attest to the fact that they understand the funders or the owners are not allowed to direct the representation. And there are very detailed regulations in place to assure that the lawyer understands if you do let the investors control everything, you're going to lose your license.
How do you monitor what happens day to day? Or, how do we know what's going on behind the scenes?
Good question. And you don't in regular law firms, right?
Right.
I'm going to keep going back to litigation funding because it exists in every state in the US. And you don't know who's pulling the purse strings and who's pulling the litigation strings behind some lawyers.
Right.
But in the ABS law firm, we have requirements that we have certain procedures in place within the firms to assure that independent professional judgment of the lawyers is not being limited by anybody. The compliance lawyer, which is a term of art, compliance lawyer is the lawyer in an ABS law firm who's kind of like the managing attorney. It's their license on the line if something goes wrong. That person is required to do a semi-annual audit. And that means training all the people, including the investors, on what information they can have about clients, what information they can't. So regular monitoring, I would say we do far more for ABS law firms than anything that happens in traditional firms.
Can you walk us through the process? And maybe this can open up the mind of many people who, want to do something beyond just, being in their lane, so to speak, and want to access the benefits. Like, what does that journey look like?
The ABS application journey, I guess, starts with a lawyer considering that they want to partner with a non-lawyer. And I tell everybody on both sides, whether it's a hedge fund, capital fund, whatever, or a lawyer, do your homework. It's just like, it's like being engaged. You don't get engaged overnight. First, you date somebody for a while and you figure out if your values are compatible, if somebody's going to close a tube of toothpaste, whatever it is. Same thing in a law firm. Before you bring a partner on, you do some due diligence. Same thing in the ABS process. Figure out in your practice area whether it would make sense to partner with a non-lawyer, and then do your homework, do the due diligence. And it's important not just so that you know who you're working with, but because everything is going to have to be disclosed in the application. The ABS applications are very detailed. They require disclosing every person or company that will have a 10% or greater ownership or economic interest in the firm. And when I say disclose, you then have to disclose, okay, Mirena, have you had any criminal convictions if you're my partner? Have you been involved in any civil litigation in the last 10 years? Have you been investigated by any agencies? Have you had any complaints? Have you had any professional licenses revoked? So it's very detailed. It is just like the process that lawyers go through to be admitted to the bar. You take the exam, but then you also have to pass something that we in Arizona call character and fitness.
Right.
The application for an ABS requires all these disclosures about everybody who's going to be involved, what their backgrounds are. And then you also, in that application, have to disclose, okay, how are you going to protect confidentiality of client information? How are you going to comply with the trust accounting rules that we have in Arizona? How are you going to check for conflicts? How are you going to docket things? So it's kind of a proactive approach to saying, before you create this law firm, tell us that you know what you have to have in place, which, gosh, golly gee, existing law firms should be doing that, right? But we don't require it of new lawyers who start firms.
Yeah. No, that makes a lot of sense. Look, at the end of the day, I think maybe, and this is just my distant opinion, and as I continue to immerse myself and understand more of this world and how it's emerging, and maybe the corporate takeover that happened to the healthcare system might still happen to the legal system. And if it does, right, because again, if now we have access to capital, which might be unlimited, to acquire cases and develop these torts, and then the attorneys are doing what they're supposed to do, then maybe it's not the death of the legal practice as we know it. It's the birth of, like you were saying, access to the legal system for the masses, where you're able to reach out and get all the cases in every corner of the country without any limitations, and to give those people the assistance and the legal representation that they need. But there is a stigma with that. It's like corporate is going to take over, because it's corporate that then dictates the day-to-day, and then the corporate is ultimately who's paying in the back end the claims anyways. And so everything is just kind of like messy, right? Who is paying up front and who is making the profits in the back end? Is it the same people, right? I don't know that it's a direct question. It's more of like, these are the thoughts running through my head as I try to make sense of this.
Well, and those are all valid concerns. You don't want your lawyer making the decision based upon what profit will be achieved. But guess what? That's already happening in law firms. Law firms are for profit. And you don't think that there's huge pressure on every attorney in a large firm to make their billable hours or bring in that next big case? Yeah. You don't think there's pressure on a sole practitioner? Gosh, maybe I have to take on this case. Maybe I shouldn't take the depositions because I got to pay rent. So there are already financial pressures on lawyers. And what I have repeatedly said is, most of the lawyers that I know and I work with have backbones. Seriously, they know what cases they should be taking. They know when they shouldn't take a case, and they know if they are going to get in over their head financially, it wouldn't be good to get litigation funding if it's going to control too much, and it might not be good to be in an ABS. They already make those decisions.
They do. They make those decisions, but I also think attorneys are, the kind of people that are very concerned about their license, and also they want to make sure that they're not going to be put out of business completely. So you think a lot of care and thought process goes into a partnership with a non-lawyer. And at the same time, because I'm in mass torts, I also see this this rush. It's like a gold rush, right? Everybody wants a piece of it, and everybody wants to establish an ABS. And so in that process, all these people are submitting applications. I'm sure you've seen tens, if not hundreds of applications. What does that process look like, right? When people are coming to you, whether it's for advice or whether they're in front of you to get an ABS approved, what is it that you and your colleagues are looking for to, distinguish who is, right and who's not right for that arrangement?
Well, in the ABS regulations, don't limit the number of ABS law firms in a practice area. And basically, it is like taking the bar exam. If you meet the criteria, if the people who are going to be involved in the firm are above board, not convicted felons or disbarred lawyers, because neither of those can be your partners, then the ABS committee actually has an incredible staff at the Arizona Supreme Court that do the background checks, and they will ask very detailed questions because they really do want to know who are the folks up the chain who might be making decisions in that ABS law firm. And they do those background checks, and then the ABS committee will look at the applications, which also have a very important provision in the applications, because the application asks which of the regulatory objectives will this ABS law firm meet? Why do you need an ABS law firm? Why aren't you just a regular law firm? And you have to be able to explain How is this going to promote access to legal services or diversity in the legal profession? How are you going to uphold ethical obligations and professionalism? So all of that is part of the process. And again, I would say, I think the ABS process and the regulations are far better at assuring that the people who are involved in these law firms understand they have an obligation here to serve clients. This is not just about the bottom line. It's a for-profit firm, so yes, you can make profits, but it is about representing the clients.
Yeah. I don't know why I thought of this as you were talking, but it's a little bit analogous to like making alcohol legal, right? It's like, or legalizing marijuana, or, it's people are doing it. And, sort of the debt structure, litigation finance is, the way that Wall Street has entered the space. But maybe the ABS provides more oversight, more regulation where, hey, you can have equity, but just know that you are going to be audited. You are going to be, reviewed and ensure that you are fit to be in this partnership. And so I think having that oversight does regulate. I mean, I remember when capital first started entering our space, that there were questions in courtrooms by judges all the time to what extent the capital partner had visibility to the legal strategy, to what was going on behind the scenes. And many times it was an issue that couldn't be overcome. Other times, there's just this frustration of lack of regulation with litigation finance because it is the wild, wild west. Right. But again, depending on who you're talking to, I mean, look, the traditional lawyer that is just used to practicing law and isn't necessarily on the business lane thinks this is the worst thing. And I have those conversations on a regular basis. I'm sure you get those emails. I'm sure you get stopped to have these conversations. How do you show those people the opportunity instead of panicking and only seeing the worst? Like, what's your attitude when you come across these people?
I'm smiling because when the regulations first came out, I received multiple, we'll just say extremely angry, irate voicemails and emails. And like, really? You're yelling at an ethics lawyer and I can see your name. Huh. I'll just make a note of your name, but thanks. And I get change is scary. Any change is scary. I mean, my gosh, our profession is trying to deal with ChatGPT right now, and we know how well that's gone so far. I recognize the concern, but number one, you're not going to have Wall Street gobbling up every law firm in Arizona. That's just not going to happen. Number two, you don't have to participate in this. I have a law firm in Arizona. It's not an ABS. I'm doing just fine, thanks. This is an option. It is an option for people to consider. And to be candid, I think when the Arizona Supreme Court's task force was reviewing these rule changes, they didn't really contemplate that there would be a large influx from Wall Street. That was not contemplated. And honestly, of the 49 ABS law firms that are currently licensed in Arizona, only 40% of them are involved in personal injury and mass tort. And I would say those are the ones that more likely than not have capital investment, hedge fund investment. Most of the other ABS law firms, a lawyer and an accountant, a lawyer and a social worker, a lawyer and their office manager, patent agent and a lawyer. It's people just trying to partner with other professionals that they regularly work with anyway. And They want to be a one-stop shop for clients.
That's fascinating. I didn't know that was the ratio. So when a hedge fund comes to you and they want to partner with a lawyer in Arizona, is it the entity or is it an individual at a hedge fund that typically goes on the application?
Yes. Yes, it's both.
Okay.
And that's a great question, but the application will ask who owns 10% or more, and then that might be a company. It might be a holding company. It might be an LLC. Then it's also going to ask, okay, who are the decision makers in the law firm? Who are those decision makers going to be? And that might be the officers or the fund manager who's going to be on the board of the law firm. Mm-hmm. So you're making the disclosures as to everybody.
I see. And so as long as the hedge fund or the individual basically stays in their lane, they're not, working on cases, meaning they're not trying to pretend they're lawyers, then it's okay. It's okay for them to look at the files. It's okay for them to look at the medical records. It's okay for them to, where is the line?
Wow, I wish there was that bright line. Okay. But I'm smiling because they stay in their lane, just like at a traditional law firm. You're going to have a CFO, right? You're going to have a CIO, hopefully, because lawyers are really bad at finance. So they're going to have somebody who's in charge of accounting and accounts receivable and income and all of that. They're going to have somebody who's in charge of technology. Really, the ABS regulations look at, okay, then why don't we just make those people partners? As long as you disclose who they are, they stay in their lane and they bring their expertise. If you were a part owner in an ABS, you would bring your expertise in finance, in understanding funding, in understanding capital accounts and all of that, which I'm just an ethics lawyer. I don't understand any of that. Yeah. You bring that expertise. And so if you are part of the law firm, the ABS law firm, then yes, you could look at the medical records, but why would you want to? You could look at the pleadings. Again, why would you want to? You rely on the lawyer for their expertise, and you bring your expertise to the table. If you're farther out, like if you're an owner of one of those holding companies or one of the managers of the hedge fund, yeah, that's where I would say, as an ethics lawyer, and I think the compliance lawyers would say, you know what, you don't have any need to know the names of the clients. You don't have any need to access their medical records. Really, all you want to know is, what was our revenue this month? What were our costs this month? And that's the information you get.
Yeah, the business arrangement side. Mm-hmm. Which, again, it makes a lot of sense. It's just uncharted territory, right? And so it's just not been that way ever. And now it is. And so the implications of what could go wrong, I think it scares a lot of people, including I've talked to Arizona lawyers who are really scared and think this is really bad for their state, and they didn't want to, they don't like that Arizona had to be the first state because they don't know what to expect, right?
And I appreciate that, and yes, all the hate mail that I received were from Arizona lawyers. Thank you. But let's be realistic about it. Okay, so maybe your competitor might be an ABS law firm and they have a bunch of money to spend on advertising. Guess what? Your other competitor might be a PI firm that has litigation funding and has taken out debt with a funder, and they're getting the same investment for advertising. So just because the ABS exists doesn't mean that you're not already having to deal with Wall Street coming into Arizona. Right. It was already here.
So if the ABS is established, and because this is my domain, mass tort, PI, litigation finance, say that now a lawyer and a hedge fund have partnered, and that hedge fund looks at Arizona as the gateway into, say, national acquisition, case acquisition. and they have unlimited access to capital. And so they can come in, they can set up shop in Arizona, say all the advertising happens in Arizona, the intake, but then all these cases are being farmed out, as the language goes in our industry. Is that, I assume that's okay? Is that acceptable?
Maybe.
Okay.
And I just gave a bunch of people a heart attack, but I'm going to say maybe, because an ABS law firm is a law firm. It is not a referral service.
Right.
And that is very important. People in the mass tort arena need to understand this, because we actually have one bar complaint pending right now, expressing a concern that a firm is merely referring cases out to other law firms.
Right.
That's not a law firm. A law firm right now, you can sign up a client. I would not do this, and please, anybody who's listening who's in mass tort, I have no interest in Camp Lejeune. So I could sign up a client right now and say to a client in any state who happens to see my website and says, well, hey, Lynda, I'd like you to represent me in a Camp Lejeune claim. Okay, I'm admitted in Arizona. I can sign you up. I can get all your medical records and everything. I'm not going to be trial counsel because I don't do that kind of work. So I'm going to have to co-counsel with this other lawyer who does that kind of work and would have that expertise. That's fine, as long as I am providing, the Arizona lawyer, am providing some substantive input into this matter, even if it's simply client intake, review of medical records, and having a system of communication so that if the client can't get a hold of trial counsel, they know I'm on the hook. I'm one of their lawyers, so they can come to me and ask questions. And then I have to stay on top of how the client's case is being handled.
Mm-hmm. So you're saying you can't just be an empty office in Arizona and say the phone numbers, go through that office, but somebody else in Florida answers the phone, does the case intake, and then just right away refers the case out to a law firm in Florida, for example, right? That's not allowed.
You have to be a law firm. So even if you don't have 100 people employed in Arizona, you, as an Arizona lawyer, have an obligation to be able to say, I have provided something substantive to this representation. And I might, again, in a traditional law firm, I might sign up that client. I wouldn't, thank you, but I might, and say, I'm going to hand this off to trial counsel because they have the expertise. They're going to be in charge of all the strategy. They're going to be in charge of all the motions and all the expert witnesses. Or I might say, I'm going to sign up the clients and I am investing money. I am advertising and I will communicate with clients. That's fine. But if I am just simply funneling money to trial counsel to advertise, and I'm not actually having any substantive role in the representation, that gives me pause for concern.
Okay.
Because that's not a law firm.
Yeah. So you would be able to see that at the application stage, or?
Great question. Probably not. No. Because every application, if it involves something like mass tort, the committee more likely than not would ask questions about, well, are you going to be hiring Arizona lawyers? What's going to be your role? If you're going to be referring everything out, that's problematic. Yeah. And so far, applicants have said, no, we're going to be a traditional law firm and we will be working with the clients. So
in terms of the long term, like 5 years down the road, do you foresee what the landscape is going to look like? Because not only do we have now this opportunity that's available to non-lawyers, specifically people with a lot of interest coming from Wall Street, but sprinkle on top the Chat GPT. And what does the future look like? Have you thought about that? Because I have to say, I not lose sleep, but I certainly, I'm so I'm so invested in this industry and I love what I do and I care for the industry. And I'm always wondering, 5 years from now, is it going to be what it is today? Or is it going to be completely different where many people are going to be out of a job? I mean, what are your thoughts?
Boy, if I could predict the future, I would have retired a long time ago. But I am hopeful. And I've been doing this a while, representing lawyers for a long time. And I would say I appreciate change is scary. I appreciate that change in the legal profession is glacial because lawyers are resistant to risk and change, which is good, right? They want to make sure they understand all the pros and cons. First, I don't see Chat GPT eliminating lawyers because, as we've seen in the news, Chat GPT can make up stuff, and that's a problem for lawyers, and that's a problem for clients and consumers of legal services. If they put into Chat GPT, please draft a complaint for me to sue Acme Company. Okay, well, unless you know what you're doing, you might have the wrong law cited. You might have cases made up. Yeah. So I don't think Chat GPT is going to eliminate lawyers. I think it probably will help lawyers be more efficient. Mm-hmm. It's kind of like a giant form file that large firms all have. So I don't see technology eliminating us. I think the human interaction, just like we're having, I mean, we could have Chat GPT just doing this podcast, right? But people would rather hear humans talking about it. I think lawyers will be around for a while. And I know there's a concern that, oh my gosh, we're allowing Wall Street in. You know what? The legal profession's gone strong in Australia and the UK, and it has not put lawyers out of business, and it has not had large corporations gobble up all the small firms. That hasn't happened because there'll be lots of people who don't want to be part of an ABS. They want to do their own thing. They don't want to have any bosses. So I think you're going to have a lot of Main Street lawyers still in small firms, solo shops, and that's wonderful. But you also might have Wall Street investing in that small town sole practitioner and allow them to maybe update their technology and make their services even more efficient, more affordable.
Yeah. I mean, look, from my experience, I think, and this has already happened, that there's going to be some monopoly going on, especially in places where, cases are really, really important in terms of inventory and it's already saturated in terms of competition. And so having, a couple of law firms be consolidated with potentially an investor and dominating that market. I mean, that's already happening in many ways. I don't think that's going to go away. I think that's going to continue. But to your point is that everybody has a choice that if you are staying current and you are doing your due diligence and you understand what your options are, both legally and on the business side, that you have an advantage because you, whoever you may be, a solo practitioner or a law firm of 10 or 50, you can access these resources and really grow your business to whatever it is that you want it to be. And that's what I specialize in, is to help law firms develop business strategies to stay ahead of the competition and, optimize their returns and revenue, because they are for-profit businesses. It's just that traditionally they haven't run that way. That doesn't mean that they shouldn't. And so the more information and resources you have as an attorney, the more, lead you'll have on your competition.
I think law firms might pretend that they weren't for profit. They want to say we're a profession, and we are. But every firm is for profit unless they are officially a nonprofit. And more firms should consult with somebody like you, because I'm not teasing when I say lawyers are bad at finance. Just because you graduate with a law degree doesn't mean you know how to run a business and have any idea how to do that. So they need expertise like yours. And why shouldn't you be able to be a partner then in a law firm?
Yeah. Well, I'm considering it. No, I mean,
lots of opportunities out there.
lots of opportunities. I mean, I hate to say this, right? But I think it's true. Like, one of the stigmas that lawyers have is that they are ruthless and they only care about the money, right? And it's like, it's a stigma that needs to be broken down, right? That was there before legal finance came in the picture, right? But I think potentially as the world of especially mass tort, mass action, class action has grown, and there is more people affected, like the consumer is truly affected by corporations. And if it wasn't for the amount of money available to a law firm to not only acquire those cases, but to work up those cases and be able to level the playing field to fight somebody like Johnson and Johnson or BP, it's hard to get full recourse, to get truly justice for your clients.
And I'm sure a lot of your audience is in the mass tort community, so they know this, but if you're not, you have no idea how expensive it is. I mean, yes, we all see commercials online, right, for all of the mass torts. Those are expensive.
Yeah.
That costs a lot of money. And by permitting Wall Street to be able to invest in a firm, you actually are expanding access to justice and access to legal services, because you might then be able to fund a lawyer who's a small town lawyer who's great expertise and has a compassionate heart and is great with clients, but they can't afford a national ad campaign.
Yeah.
They can't afford 10 years of litigation against a huge corporation and hiring all the experts that are needed. It's the amount of money involved is just a product of, now we're years and years into mass torts, and it costs a fortune to do this. And so the consumer who has a possible claim, number one, might not even know it. Yeah. So that's what a lot of this is. It's educating consumers about their recourse. And then number two, having the finance to be able to front all this money, because mass tort lawyers don't charge their clients the costs up front. Yeah. They front all that money.
Absolutely. Your thoughts on Utah? I don't know how familiar you are, but I have just heard some rumors that Utah has been a little bit all over the place. First, they considered doing the same thing, which is allowing lawyers, non-lawyers to partner. And then most recently, they've made it a felony, is what I heard. Is that true?
I've not heard that. I know, and this I would say my personal view is, I'm sad to hear that lawyers who are frightened by change are trying to go to the legislature and restrict change. Yeah. I think that's short-sighted. I think it hurts the profession and it hurts consumers. And shame on them for being afraid to let Utah have their sandbox, their pilot project. And it does permit both partnering with non-lawyers, and it permits something different than Arizona. It permits non-lawyers, including technology, to provide legal services. So it's kind of a different idea. It's not just permitting non-lawyer partnership, but also expanding who can provide legal services.
Interesting. Yeah, this was something I actually overheard at a conference last week. So I hadn't done my research, so I thought I'd pass that by you. But if it's true, then it's quite the swing, right? From wanting the change or seeing the potential to making it, making it a crime, if that's actually the case, or just simply not allowing it. But I do think that there is a movement across the nation to try and warn other, states from not doing something like this. So, but as you I'm sure, have experienced, there is a backlash regardless what position you take, because everybody has an opinion and everybody thinks they are right. So
and that's why I think Arizona's ABS program is being so careful. I would say, if anything, we overregulate the law firms that are being approved by requiring so much disclosure and so much looking behind the curtain to see who's actually controlling everything. And everybody who is a licensed ABS law firm in Arizona is a representative of the program. So it's to everybody's benefit that we approve firms that are trying to comply with the regulatory objectives and that everybody abide by the rules, because you're right, we want to show this is an opportunity for lawyers. This isn't being done to lawyers, and that's the part that disappoints me when I hear of lawyers saying, this is horrible, this is a travesty. You know what? This is being done for you as an option, not to you. Mm-hmm. You can choose it or not.
No, that's a great point. And it's a great way to end really our conversation on this topic. And look, I know it's a topic that's going to evolve. So I think I might invite you again, depending on what this landscape looks like 12 months from now. But I really, truly appreciate you taking the time to educate me and my audience on the implications of Arizona allowing non-lawyers to participate and share fees with lawyers. And I think you shouldn't answer those emails and those phone calls you get from all of those people. Watch this podcast.
Yeah, it's been a pleasure. And thank you for getting information out there to people about the programs.
Yeah, my pleasure. Thank you, Lynda.
Thanks.
Stay tuned for upcoming episodes available on popular platforms such as iTunes, Spotify, and YouTube.